So uh, hello everyone. Very good evening. Uh, आशुतोष मेरी आवाज आ रही है?
Yes, sir.
तो thank you so much for giving me this opportunity to deliver the third session on a summary suit in the pursuance of this civil drafting course internship program. Sorry. Thank you so much, Ashutosh and team Vidhigyata. So today we are going to understand a very practical and important aspect or concept of civil law, that is summary suit. So without any delay, let's begin with the session. Normally, when a civil case is filed before a court, it takes so much time because there are so many things that has to be done, like pleadings, evidence, witnesses, cross-examination, and so on. But in certain cases, the law says why waste the time. When the claim is very clear and straightforward, law thinks that there should be some speedy trial or some speedy justice to be given to the parties of the civil matters. This is where the summary suit under Article 37 of the Code of Civil Procedure 1908 comes in. We can summary suit is a very special and speedy procedure which is commonly used for recovery of money in cases where there are clear written evidences like promissory note, bill of exchange, and written contracts. These written contracts and all these things, we have had a wonderful sessions, good sessions on drafting of sales deal. We have discussed on these things. This promissory note and bill of exchange thing is governed by the negotiable instrument act. So therefore, these written documents must be in existence for this procedure of summary suit to bring in picture. So let's understand this concept with the example. Suppose there is a businessman, namely A in Delhi, and B another businessman or trader in Lucknow. A sells goods worth rupees 10 lakh to B, and now B has given A a promissory note promising to pay this amount within 3 months, along with some kind of interest, for example, 10% or 12% interest. So, 3 months have passed, but the situation is that B has not paid any amount to A. Now, the question arises here is that does A really need a long trial to prove his case? So, what does the law, what does the procedural law relating to civil matters in India states that there is no need to take a long trial or so many arguments before the court of law, because there is existence of some written document in the form of promissory note. The amount is very certain and fixed, and liability here is very clear. So, in case when for summary, there is some noise. Uh, I request the participant to mute his audio. Okay. Now there are certain theories from theories of jurisprudence from various schools, various proponents. We can connect this concept with. There is nothing so much to deliver on this. Just some glimpse I would like to tell you that this concept can be correlated with the social engineering concept of the Roscoe Pound, which says that law is a tool of social engineering. So here in this case, we can connect with it that here A's interest is of getting his money back quickly, and B's interest is that there should be some fair opportunity to defend. However, it is very it is in the restricted sense. If you see the code of civil procedure, the fair opportunity to defend, and it can be correlated with the Jeremy Bentham's utilitarianism and Eyring's theory of interest also. Please change the slide. Yes. Uh, as so far as the Order 37 of the Code of Civil Procedure 1908 is concerned, so it applies primarily in cases where the plaintiff's claim is clear, specific, and it is supported by some written documents. It is involved in the suits based on the negotiable instruments that we have discussed few minutes ago, such as checks, bill of exchange, and promissory note, as defined in the NIE Act 1881. So there should be some existence of these things. ये प्रोविजन उन केसेस में अप्लाई होता है जहां पर प्लेंटिफ एक फिक्स्ड या लिक्विडेटेड अमाउंट जो पहले की तय की हुई कोई राशि रही हो या क्लियर डेप्ट रिकवरी करना चाहता है वहां पर अप्लाई होता है और जहां पर ज्यादा फैक्ट्स पर डिस्प्यूट होने की जो संभावना है चांसेस होते हैं वो कम है. So, what makes a summary suit distinct is the restricted right of the defendant to contest the case. As I have already told that the defendant को chance देना to defend the case is very restricted or limited in the civil procedure code. Unlike the ordinary civil suit that is brought before the court, the defendant cannot automatically file a written document and proceed with the trial. Instead, under Article 37, what defendant has to do is just to he has to first seek the court's permission by filing an application for leave to defend within 10 days from the service of summons, supported by affidavit disclosing some substantial and bona fide grounds of the defense. तो इन्हीं परिस्थितियों में जो है डिफेंडेंट को लीव टू डिफेंड कुछ ऐसी परिस्थितियां हैं जिसमें मिलेगी कुछ ग्राउंड जैसे हो सकता है जेन्युइन है और कोर्ट को या तो डिफेंडेंट सेटिस्फाई कर दे कि दैट ही हैज सम रीजनेबल ऑब्जेक्शन रीजनेबल या सम जेन्युइननेस उसके पार्ट पे है अदरवाइज जो है वो रिजेक्ट हो जाती है उसकी कोई भी एप्लीकेशन हो. नेक्स्ट स्लाइड प्लीज. The court will grant leave to defend under Article 37 only when the defendant discloses a real and genuine and some substantial issue. It should not be vague, it should not be sham or some illusory assumptions or assertions that he has taken before the court. So the defense must raise some trivial issue, some tribal issue, not trivial issue. Meaning, it means that there is a requirement of judicial scrutiny, judicial examination, or to create a reasonable, which creates a reasonable doubt regarding the claim that has been mentioned or that has been claimed by the plaintiff in his prayer. So, additionally, leave may be granted where the defendant's assertion indicate that the plaintiff has some element of the claim, such as the consideration, execution, or delivery of the instrument. रीजनेबलनेस बहुत ज्यादा इंपॉर्टेंट है जेन्युइननेस होनी चाहिए किसी अननेसेसरी फैक्ट्स की तरफ अननेसेसरी चीज की तरफ इट शुड नॉट बी रिफ्लेक्टेड ओनली देन देयर आर चांसेस दैट हिज एप्लीकेशन टू हिज लीव टू डिफेंड विल बी ग्रांटेड. So it's purely procedural in nature. It does not alter the substantive nature of the case, nor does it affect the jurisdiction of the court. Its purpose is very limited, serving the purpose of speedier mechanism or speedier justice for as so far as the money suit or summary suit is concerned or money related matter is concerned. For adjudication, clear and undisputed money claims should be there without any unnecessary delay. While still preserving some fairness by allowing defense to appropriate cases. Next slide, please. The object of Order 37. I think slides are little bit scattered. Okay. Uh, Discretionary power of the court as जो लीव टू डिफेंड वाली चीज है यहाँ पे वाइड डिस्क्रिशनरी पावर ऑफ द सिविल कोड दी गई है बट नॉट what the powers have been given under order under section 151 of the code of civil procedure वो powers यहाँ नहीं यूज हो सकते हैं और arbitrary यूज नहीं कर सकते हैं. So far as the extent and applicability of the this summary suit is concerned, so कहाँ कहाँ jurisdiction lie हो सकता है तो it can be city civil courts में हो सकता है, high courts में हो सकता है, courts of small causes में हो सकता है, other appropriate court तो mainly decide होता है what is the pecuniary jurisdiction of the concerned court. Change the slide. Hello. स्टेप्स की बात करें एक स्लाइड कहीं पे मिस हो गई है जितना मुझे याद तो दो कोई नहीं यही डिस्कस करते हैं ठीक है दो स्टेप्स में है जो प्रोसीजर समरी सूट का बिगिन होता है पहला रूल 2 और रूल 3 इसको कंसीडर करना पड़ता है रूल 2 क्या कहता है रूल 2 के अंदर जो है द कोर्ट इश्यूज समन फॉर अपीयरेंस टू द डिफेंडेंट who is required to enter appearance within prescribed time 10 दिन का समय उसको मिलता है he has to react on issuance of or on receiving the summon. Once the defendant appears, the plaintiff serves the summon for judgment. If the defendant fails to enter this appearance, then the plaintiff become entitled to immediate degree without any unnecessary, unreasonable delay. The court will grant degree to the petition. Petitioner, which is excusable without any further delay. Step 2 is a leave to defend under order 37 rule 3 in which the defendant must comply with the for the permissions to defend the suit within 10 days that we have discussed for receiving the summon of the judgment. There should be some attachment with these documents like affidavit which must clearly disclose the facts that there is some kind of defense. Only then the court will consider the case. There are high probability that his defense will be considered, and so while we have discussed, there should be some reasonableness, some real, substantial, and it must raise some tribal issue. Only then it is entertained by the court. Next slide, please. दो तरह की लीव होती हैं एक कंडीशनल लीव है एक अनकंडीशनल लीव है तो कंडीशनल अनकंडीशनल लीव जो होती है वो कब मिलती है तो मतलब देयर शुड बी सम unconditional leave is some where the defendant is allowed to contest the suit freely without any restriction. And जब conditional leave की बात करें तो in this case defendant is permitted to defend the suit subject to certain conditions such as depositing some certain part of the amount claimed, furnishing security or complying with any other terms that the court considered just and reasonable in the circumstances. However, leave to defend will be refused where the courts find that the defense lacks some merit. Usually, जब कोई frivolous या unreasonable tribal matter नहीं है उसको लेकर के defendant चला आता है तो ऐसे केसेस में क्या होता है leave to defend जो होती है उसको refuse कर देती है. Next slide, please. So when the defendant admits the part of the claimed amount which is due, Order 37 requires that admitted amount must be deposited in the court. So this condition ensures fairness, prevents misuse of summary procedure. If the defendant fails to deposit the admitted sum, the court may refuse leave to defend as the admission indicates clear and undisputed liability to that extent. At at the stage of hearing of the summons for judgment, the court examines whether the defendant has sought and justified leave to defend, or if the defendant fails to comply with the fails to apply for the leave, or if the court refuses such leave on the ground that there is no existence of substantial issue, the plaintiff becomes entitled to immediate decree will be granted without any further delay, without any full trial, as the section Article 37 of the law requires. Next slide, please. बहुत सारी चीजें हैं, स्लाइड्स में मेंशन है, आप लोग ले लीजिएगा, समझ लीजिएगा। बहुत ज्यादा डिटेल में थ्योरेटिकल पार्ट डिस्कस करने का कोई मतलब यहाँ पर नहीं है। तो नेक्स्ट वी हैव under although there are some strict timelines that is prescribed by the law, court may excuse delay in entering appearance or in applying for leave to defend if the defendant is able to show some sufficient cause for such delay. Which ensures that the procedural rigidity does not override justice, particularly where the delay is justified and not deliverable. At the same time, there is no straight jacket formula. कोई formula नहीं है for granting the leave to defend. It depends completely upon the discretion of the court, discretion of the judge. Each case is decided on its own merits, its own facts and circumstances, which is guided by the judicial discussion. Judicial discretion, the judge applies his mind only to decide whether leave should be granted or not. However, this discretion is not unfettered. The court must always act. What the law requires is to judicially, fairly, and in accordance with the principles of natural justice, ensuring that there is a balance between speedy disposal of the case as well as defendant right to uh, give him opportunity to hear to defense. Next slide. Setting aside of the yes. So the court under Article 37 has power to set aside a decree passed in summary suit in special circumstances such as where the defendant was prevented from appearing due to sufficient cause. In such cases, what happens is that the court may also stay the execution of the decree and grant the defendant an opportunity to defend the suit, which ensures that justice is not defeated by procedural constraint. However, it is very important to note that as we earlier I have also told you that section 151 of the Code of Civil Procedure 1908 will not be applied. Inherent power of the civil court cannot be invoked here, which highlights that summary suits are governed by a self-contained procedural schemes and any relief must be granted in accordance with the specific provisions laid down under the law as per Article 37 of the CPC requires. Next slide, please. The distinction between yes, ordinary suit and summary suit. So there are basically two terms or two bases on which distinction between the ordinary suit and summary suit can be done. What happens in ordinary suit is that the defendant has an unrestricted right to defend, unlike the money suit in the case. And the matter proceeds with a full and detailed trial, including pleading, advancing evidences and arguments on from the both sides. If the decree is passed, it can generally be challenged only through appeal or review in ordinary suits. In contrast, if we talk about the summary suits or money suits, it follows a fast track system. Fast track procedure follow करता है, where the defendant cannot defend as a matter of right, and first because he has to obtain leave for defend by disclosing certain substantial defenses that his case is tribal, his case is genuine, his case is not weak and sad. If such leave is not granted, the plaintiff is entitled to mm, immediate decree without a full trial. Additionally, unlike ordinary suits, trial courts itself may set aside the decree in special circumstances under the provisions of the Order 37, which makes it more flexible yet very expedient mechanism for resolving clear money. So now we are done with the theoretical part. There are so many things associated with the this summary suit order 37. If we are going completely into the theory part, there are so many judgments in this regard on the discussion of leave to defend and all these things. Uh, फिर कभी हम लोग ऐसा कुछ सेशन थ्योरी पे ऑर्गेनाइज होता है, we can have some good deliberation on it. Now we are coming on the this drafting part of the summary process, summary suit. ओके, पहले तो हम लोग रीड कर देते हैं ये जो सैंपल है. Yes. There is a there are two companies involved. Sunlight Infrastructure Private Limited, which is a company incorporated under the Companies Act 2013, having its registered office at Cyber City, Gurugram, Haryana, which is engaged in the business of civil construction and industrial designing. The company is represented by its managing director, Sri Arjun Mehta. Next party we have is Greenfield Industries Limited, having its registered office at this place through its director, Mishra. This approached Sunrise Infrastructure Private Limited in January 2024 for the supply of the industrial plywood, steel frames, and related construction. And between February 30, 2024 to okay, Ashutosh, please फ्लाइट चली गई है. नहीं नहीं, ठीक है, ओके, ठीक है, ठीक है. Between 2024 February 2024 to August 2024, there are some transactions that has taken place between both the parties, and subsequently the parties have also entered into an agreement whereby Sunrise Infrastructure Private Limited agreed to undertake construction of the defendant's industrial warehouse as per the mutually agreed site plan and specifications. The construction work uh, was completed and possession of the warehouse was handed over to the defendant in September 2024. Next, please scroll the document. Yes, so many things, so many transactions that have taken place here by way of checks, and approximately total 8 lakh transaction, as I can see here, has taken place. Uh, the check was presented by Mr. Plenty for encashment, but it was dishonored on this date with remarks of insufficient funds. The plaintiff immediately informed the defendant about the dishonor and requested payment for the outstanding amount along with the interest 12% per annum. That is the important thing that we will have a discussion on it. Thereafter, the plaintiff has the plaintiff has issued a legal notice, very important date, demanding payment of 8 lakh along with the interest from 1st October 2024. However, the defendant neither replied to the notice nor cleared it. Okay, इसके बाद ठीक है. इसके बाद कई सारे अमाउंट्स हैं, अनपेड हैं, टोटल 8 लाख का अमाउंट है. तो केस को पढ़ के फ्रॉम द केस एंड सर्कमस्टेंसेस वी कैन सी दैट द प्रोसीजर ऑफ द समरी सूट can be applied here if we adopt the mechanism of civil procedure. So, keep the draft portion. Okay. सबसे पहले जुडिस्टिक्शन क्लॉज, वेरी इंपॉर्टेंट थिंग. तो दो ड्राफ्ट हमने 2 या 3 ड्राफ्ट पढ़े हुए हैं पहले. तो एज ऑलवेज से कि जुडिस्टिक्शन क्लॉज हैज टू बी मेंशन्ड first. For this line in the court of the Honorable District Judge Gurugram, so this we say is the court heading or title of the court or jurisdiction of the court. So this clause tells us which court will have authority to hear the case. It is very important uh, because the suit must be filed within a correct jurisdiction. If it is filed in a wrong way or in a wrong jurisdiction, it leads to the rejection of the claim. Applies in both ordinary suit as well as money suit also. So we will have to specifically, as a drafter, as an advocate, as a counsel representing the petitioner, have to mention which is required by Article 37 of the Code of Civil Procedure to inform the court that it has some jurisdiction under the Order 37 of the Code of Civil Procedure. Next, we have in the matter of clause, which is known as cause title, a plaintiff versus defendant, Mr. Major Sunrise Infrastructure Private Limited through its managing director and Mr. Sri Arjun Mehta, who is plaintiff of the case, and versus Major Greenfield Limited through its director, Mr. Rajiv Malhotra, defendant of the case. So this is a cause title which identifies that the parties to the suit who is filing the case and against whom the case is being filed here. It is very relevant because it clearly establishes the legal relationship and ensures there is no confusion about who is suing whom. Next, we have a memo of the party in the index thing. Yes. So what is the purpose of this index thing or memo of the parties is that this clause gives complete details about both the parties, the such as names, status, address, and representation. It relevance helps in the court is that it will be easy for the court to issue summons and ensure proper identification of the party. Please scroll. Yes. Keep on scrolling. The parties think we have discussed. Nature of the suit, summary suit which is there. हाँ, next वाली next scroll, next page पे हाँ ठीक है. अब यहीं से शुरू होता है एक नई चीज, नेचर ऑफ द सूट या हेडिंग ऑफ द क्लेम, which has to be mentioned as a summary suit under Order 37 of the Code of Civil Procedure for the recovery of this amount along with the interest as well as cost of the. So this clause specifies that the suit is of summary nature or summary suit है, which mentions the amount that has been claimed. This is very crucial under order because Order 37 applies only to certain types of cases like recovery of money based on written documents. So far, we have so many things we have discussed on this. So it informs the court that the fast track procedure should be followed. Next, we have yes, the description and locus of the plaintiff. कहाँ पे plaintiff की property situated है, कहाँ registered है. तो ये clause क्या करता है? As the clause reaches that the plaintiff is company incorporated under the Companies Act 2030, having registered his office from this at this place. It is being managed by Mr. Arjun Mehta, who is duly authorized to sign, verify, and institute the sued, if any, on behalf of the plaintiff. So this clause establishes who is the plaintiff and what is the authority of the plaintiff. So in this case, in case of companies, it is very important to show that the person like managing director is authorized. Without this, what happens is that suit may be challenged as it is not properly instituted. Next is the nature of business of the plaintiff. So this clause has to be written as written here is that the plaintiff company is engaged in the business of civil construction and industrial designing and supply of construction material. This has to be mentioned because it connects the plaintiff's business with the transaction in dispute, making the claim very logical and believable. यहाँ पे weakness या stand on the part of the plaintiff की chance नहीं रहते हैं. So this is very इम्पोर्टेंट फॉर डॉक्यूमेंट। उसके बाद हम बात करते हैं इनिशियल ट्रांजेक्शन्स की या फॉर्मेशन ऑफ रिलेशंस की, वन बाय वन जैसे कि मेंशन किए गए हैं। उसके बाद में अच्छा ट्रांजेक्शन की बात है तो ट्रांजेक्शन्स मेंशन है, डेट्स मेंशन है, इनवाइस और अमाउंट्स जैसे मेंशन है वैसे मेंशन होने चाहिए एक समरी सूट के ड्राफ्टिंग में इन अ प्रॉपर टेबल व्हिच मेक्स द which is very crucial in summary suit because the claim must be because it has to be based on some written documents, it has to be supported by some written documents। उसी के आधार पे हम यहाँ पे मेंशन कर रहे हैं कि these transactions have taken place from these dates। नेक्स्ट इज द क्वालिफिकेशन ऑफ द टोटल 8 लाख का अमाउंट जो है बनता है यहाँ पे लाइबिलिटी अराइज होती है ऑन द पार्ट ऑफ द डिफेंडेंट, दिस हैज टू बी क्लियरली मेंशन द फिक्स्ड एंड सर्टेन अमाउंट ऑफ द क्लेम। Next, supporting records that the plaintiff maintained a duly updated ledger account. Those who are from the commerce background, they must be familiar with this ledger thing, reflecting the above transaction and outstanding balances, which shows that proper accounts have been mentioned, proper maintained, proper records have been maintained, which strengthens the plaintiff's case by proving that the claim is very genuine as well as documented. Next, additional contractual obligations has to be mentioned that the play, which as here it is stated that the parties also entered into an agreement for construction of an industrial warehouse at IMT Manish, Haryana, and the plaintiff completed the transaction work and handed over the possession of the property in September 2024. So this clause highlights that that there is an existence of written agreement between the parties. It is very much important under Article 37 to claim arising out of the written contract. Here some should be some basics. कोई घर बनाते हैं तो रूट्स सॉरी जो नींव होती है बहुत जरूरी होती है, तो जो रिटेन कॉन्ट्रैक्ट्स हैं इन द फॉर्म ऑफ जो नेगोशिएबल इंस्ट्रूमेंट के अकॉर्डिंग जो डॉक्यूमेंट्स हैं या कोई रिटेन कॉन्ट्रैक्ट है ये नींव का काम करते हैं फॉर द अप्रूवल ऑफ द केस या प्रॉपरली उन केस को अमाउंट क्लेम कर सकें और जो लाइबिलिटी डिफेंडेंट के ऊपर बनती है वो हम शो कर सकें। अब क्लॉज 7 से क्लॉज 12 तक कम्युनिटिवली मैं डिस्कस करूंगा, नॉट गोइंग टू रीड ईच एंड एवरीथिंग। जो इम्पोर्टेंट चीजें हैं वो आपको इसमें ध्यान रखनी है कि कौन कौन सी चीजें कैसे कैसे मेंशन करनी, इट इज वेरी इंपॉर्टेंट। तो उसके बाद हम देखते हैं कि क्लॉज 7 की बात करें तो ये फाइनल बिलिंग की बात करता है, विच शोज दैट व्हेन द एग्जैक्ट अमाउंट बिकम ड्यू। फिर क्लॉज 8 जो है इशुएंस ऑफ चेक की बात करता है, वन बाय वन जैसे जैसे चीजें डेट वाइज चीजें डेट वाइज थिंग्स हैव टेकन प्लेस, these things has to be mentioned. Like clause 8 states about the issuance of check, which proves that the defendant acknowledged this liability by issuing the check. Clause 9 में ये मेंशन किया गया कि that the check has been dishonored, which highlights that there has been a payment failure in making the payment due to insufficient funds, as given in the sample of of this draft, which is ground for filing a summary. क्लॉज 10 और क्लॉज 11 की बात करें तो डिमांड एंड लीगल नोटिस की बात करता है, which demonstrate that the plaintiff made genuine efforts to recover the money before approaching the court. क्लॉज 12 बात करता है लाइबिलिटी क्लॉज की, which clearly states that the defendant is legally bound to pay the outstanding amount along with the interest. Same as the clause 13 to clause 17 कम्युलेटिवली वैसे ही चीजें हैं, वन बाय वन एक एक चीजें मेंशन करनी रहेंगी। लाइक कॉज ऑफ एक्शन क्या था, टेरिटोरियल और प्रिलिमिनरी ज्यूरिसडिक्शन क्या है कोर्ट का, whether the court is competent to hear the matter or not, this thing has to be again specifically mentioned in the clauses. Then there should be indication of legal basis which specifies that the suit is filed under Order 37 of the Code of Civil Procedure, which enables a faster procedure with the limited difference. और लास्टली हम बात करें तो क्लॉज 17 की बात वो लिमिटेशन क्लॉज की बात करता है, which clarifies that the plaintiff is not claiming any relief beyond the scope of the summary suit under the as the law prescribes. So this is very important because additional or complex relief are included. The suit may lose its summary nature and may be treated like ordinary suit. अगर इस लिमिट जो परमिसिबल लिमिट क्रिएट करके एक चेक क्रिएट करके ऑर्डर 37 में रखा है, अगर ये बाउंड्री लाइन क्रॉस हो जाती है तो इट विल बी ट्रीटेड एज अ समरी सूट। पहली चीज तो रिजेक्ट ही हो जाएगा। उसके बाद ये सारी चीजें मेंशन करने के बाद नेक्स्ट हम आते हैं प्रेयर पे। प्रेयर का प्रेयर क्लॉज का ये काम होता है, इट इज हम क्या रिलीफ सॉर्ट कर रहे हैं, सीख कर रहे हैं फ्रॉम द कोर्ट से, लाइक द रिकवरी ऑफ द प्रिंसिपल अमाउंट, इंटरेस्ट, कॉस्ट। सो दिस थिंग हैज टू बी मेंशन after the completion of this cross thing. And it is why it is necessary because it gives court exact idea that what needs to be done. और उसके बाद प्रेयर के बाद में लास्टली हम अटैच करते हैं एफिडेविट और वेरिफिकेशन क्लॉज को। स्क्रॉल कर देना थोड़ा सा, एफिडेविट एंड वेरिफिकेशन क्लॉज। ठीक है, मैं ऐसे ही बता दे रहा हूँ। एफिडेविट जो एफिडेविट वाली चीज जो होती है वो इसलिए लगाते हैं बिकॉज इट इज अ स्ट्रॉन्ग स्टेटमेंट कंफर्मिंग दैट द फैक्ट्स स्टेटेड are true to the knowledge of the plaintiff along with the verification which formally declares that nothing material has been concealed. So these clauses are essential because it maintains the credibility of the suit and it is mandatory procedural requirement under the Code of Civil Procedure has to be. So with this, I end the session here from my side. Thank you so much, Ashutosh and the Vidhigyata team, for giving me this opportunity to deliver on this topic. कोई कंफ्यूजन हो विद रिस्पेक्ट ऑफ ड्राफ्टिंग तो दैट आई कैन टेल यू। है तो ये टॉपिक बहुत अच्छा और थोड़ा सा कहने को समरी सूट है, बट देयर आर सो मेनी थिंग्स, देयर आर सो मेनी लीगल डिबेट्स ऑन इट दैट वी कैन हैव अगर कभी थ्योरेटिकल सेशन ऑर्गेनाइज होता है पर्टिकुलरली ऑन समरी सूट। थैंक यू। ठीक है आशुतोष, कल मिलते हैं। थैंक यू सो मच।